Hello, and welcome to this afternoon's webinar on immigration. Today, we're going to be talking about a number of immigration-related topics. We will cover work visa options initially, and then we'll talk about green card options after that. The format of the presentation is the presentation part will take about 1 hour, and then I will answer questions at the end. So if you have questions, please enter them into the chat, and then I will go through at the end of the presentation and answer everybody's questions. Because this is public, I would recommend that you not provide a lot of personal information. If you can ask general questions, that's great. I will be sharing my contact information at the end of the presentation, so you can reach out to me with more individualized questions that you may have. If there are visas that you're interested in seeing whether you qualify for, we can talk about that. If you'd like to start a case, I would love to work with you on that as well. So feel free to ask those questions. At the end of this presentation, either later today or tomorrow, I will send an email to each of you that will have these slides attached. So don't feel like you need to be furiously writing notes or taking screenshots or anything like that. You'll have these slides. We will email those to you, and then we will also include a recording of this presentation. So I'm recording this presentation, and we'll make that available to everyone. So with that, let's go ahead and get started here. Just a quick introduction about myself. I have been practicing business immigration for over 16 years. I started my firm with my partner, Sam Adair, about 12 years ago. We're in our 13th year right now. We work with a broad cross-section of individuals and companies, particularly in technology, science, biotech, finance, education. So it's kind of a wide range of industries that we work with. And in addition to that, there are a lot of other types of companies that we work with as well. I manage the operations of my law firm. We are divided mostly between San Jose, California, and Austin, Texas, although with COVID coming around, we have a lot of people working remotely all over the country now. This is where I brag just a little bit about the firm. We have a perfect 5-star rating on Google with over 70 reviews. And the reason that's important to us is because the way we differentiate ourselves is really in the customer service, the level of service we provide. We understand that even though we do this every day, for the people we're doing it for, it's their first time, and they may not have a lot of experience with it. And so making sure that everyone understands what's happening, what their options are, and if they have the support they need is really important to us. With that, this is the agenda that we'll be covering today in today's presentation. Like I said at the beginning, we're going to be talking about what we call non-immigrant visa options. And basically what that means is that these are your typical work visas that you'll be applying for. The reason they're called non-immigrant petitions is because they don't eventually result in immigrant status or like a green card. That's the immigrant visa process. And so typically what happens is when somebody comes to the United States, they often come here with a work visa like an H-1B or an L-1, something like that, and then later move toward a green card down the road. So usually it takes a few years to get to the green card, to the actual green card, and sometimes it takes longer than that. So that's the typical flow. So that's kind of the flow of how this presentation is going to go. So with that, let's go ahead and talk about work visas now. The first work visa is kind of the most common or most commonly known, and that's the H-1B specialty occupation visa. This has been in the news a lot lately because of the H-1B lottery you may have heard about. So the way this works is there's an annual limit of 85,000 new H-1Bs that are available each year. So if you're looking to apply for an H-1B, you got to apply for one of those 85,000. Well, the issue is we have more demand than there are visas available. that means that, more than 85,000 people are applying. And so when that happens, what the US Citizenship and Immigration Service, or USCIS, does is they run a lottery. And the idea is they want to give everyone sort of an equal chance to be selected for one of those 85,000 H-1Bs. Well, about 4 years ago, they switched, or maybe it was 3 or 4 years ago, they switched to an online registration process. It used to be that in order to be included in the lottery, you had to actually prepare the whole petition. Your company probably paid an attorney to do it. And that whole big, stack of paper had to be filed with US Citizenship and Immigration Services. They collected all the many thousands of applications, and then they would do the lottery. Well, that's obviously a very cumbersome process. It's a very expensive process for companies as well, because, if they're filing all these cases and paying for all of them, and only some of them are going to be selected, that's pretty cumbersome. So what USCIS did is it switched to an online system where registrations can be done for $10 per person. And the lottery is run electronically, and those who are successful are notified, and then they prepare their applications and send them in. But what this did is it created a very low barrier to entry. And so now we've been getting so many registrations every year that the chances of being selected in the lottery are low. So this year, for example, there were almost 781,000 registrations filed. So if you're good at quick math, that's roughly 15% chance of being selected for an H-1B. And what they actually did is they actually selected 111,000 around 111,000, because what they're anticipating having happen is they're going to find some rejections, they're going to find some cases denied, they're going to have some cases withdrawn. So they try to overestimate or over-select how many cases they're going to need, estimating that when all is said and done, they'll have met that 85,000 cap. So I said 15%. That's nuanced a little bit by what we call the regular cap versus the advanced degree cap. The way the lottery is run is those who have an advanced US degree from a US institution. So we're talking about master's degree, bachelor's degree, master's degree, PhD, anything higher than a bachelor's degree. You go into that advanced degree cap. The lottery is run for those individuals. Those who are unsuccessful in that cap then go into the regular lottery, and then they get another chance. So those in the advanced degree group had a higher chance, higher than 15% chance, maybe more like 20 to 25%, whereas those in the regular cap actually had lower than 15%, probably closer to 10%. And so the way this works is with the lottery was run in March. Selections were announced last month, and then now we're in the process of filing cases that were successful. So if you're interested in an H-1B, you're going to need to wait until next year when the new fiscal year begins. It's 6 months before the beginning of the fiscal year. So we're talking about in March, they actually run the lottery. So if you're interested, you'll need to have your employer register for you in March of next year. If you're selected and your H-1B is eventually approved, then your start date is the beginning of the government's fiscal year, which is October 1st. So those who are selected this year, their H-1B will start on October 1st of this year. Those who have to wait till next year, it will obviously be October of the following year that the H-1B will be selected. With that, I think, so in terms of the validity, H-1Bs are good for 3 years and then a 3-year extension. So 6 years total, that's the limit. But as we talked about, as I mentioned earlier, there is a process whereby people can begin the green card process while they're in an H-1B. And if that happens, then you can potentially extend your H-1B beyond those 6 years. For some individuals, it can really be sort of indefinitely until the green card process is completed. There is something called premium processing that is available on some cases, and I have a slide toward the end that summarizes this and will hopefully be helpful as a reference, which cases are eligible for premium processing and which are not. Cases that are filed with regular processing right now are taking about 6 to 12 months. So that's obviously a long wait. Those cases that are filed with premium processing, it's actually, the government has 15 days once the case is filed under premium processing to respond. That response may be an approval, it could be a denial, and it could be a request for additional evidence. I'm also going to talk about the cost for premium processing a little bit later. There's an additional cost with that as well. H-1Bs must be employer sponsored. So this is not a self-sponsor option. You have to have an employer willing to do this for you. And then if you have an employer that sponsors your H-1B and you want to change to a new company, that new company needs to transfer the H-1B to that company just before you can start working for that new company. So the H-1B is nice in terms of its flexibility, being able to be extended, indefinitely until you get the green card, also being able to transfer to new employment. Those things are helpful for the H-1B. Dual intent. I'm going to mention this just really quickly. So what dual intent means is it means that you have the intention of coming as a non-immigrant. So that's an H-1B, like a work visa. But you also intend to apply for a green card down the road. So that's where you have the dual intention of being a non-immigrant and eventually filing for an immigrant visa. All right, for those who joined later, again, I'm asking everyone with questions to go ahead and put those in the chat, and then I will get to those questions at the end and answer those questions. It is anticipated that this presentation will take about an hour, and then we will answer questions after that. For those who are on, if you would please be sure your microphone is muted, that would be great. We're getting just a little bit of background noise. All right, now the next work visa we would like to talk about here is the L1 for intercompany transferees. So what this means is if you work for a company outside of the United States for at least 1 year, and that company has a US office, you can transfer from that foreign office to the US office under an L1, either L1A for those who are executives or managers, or L1B for what we call specialized knowledge. And so I'll explain a little bit about what each of those means. So L1A is for those who operate in a managerial capacity for the company. And so the easiest way to prove this is if you have direct reports, that are sort of at a professional level, not considered frontline workers, let's say degreed professionals, for example, then chances are you can qualify for an L1A. The question comes up sometimes, well, I am a manager, but I don't manage people directly. Can I still qualify for an L1A? The answer is yes, you can, as someone who is a functional manager, meaning you don't have direct reports, but you manage a function of the company that is a critical piece of the company. Those cases, I will say, are more difficult because it's easy to prove that you have direct reports. It's more difficult to prove that the function you manage is essential to the company. So we would look at things like your budget, the results of the work that you did, the area that you worked on in terms of its importance to the overall operation of the company, things like that. So like I said, it's a little bit more complicated, but it can be done. L1B, on the other hand, is somebody who is not a manager, but they have some sort of unique or advanced knowledge that is not readily available in the United States. A lot of times that comes by virtue of having worked for the company for at least a year. You've learned tools or skills that are specific to the company that are not readily available, and that knowledge is really critical, and we can demonstrate that to the government. Then you can qualify for an L1B. So L1s are good for an initial period of 3 years, followed by 2-year extensions. If you're L1A, you get 2 2-year extensions, so a total of 7 years. If you're L1B, you get 1 2-year extensions for a total of 5 years. Now, I talked about earlier the flexibility of the H-1B that's nice to be able to extend beyond those 6 years. Unfortunately, with the L1, that same option does not exist. So that 7-year maximum or that 5-year maximum are fixed. And even if you start the green card process, you can't extend beyond those limits. So a lot of times people that are in L1 status, we recommend trying to apply for an H-1B. Now, the issue is with the H-1B cap being so, the likelihood of being selected in the lottery being so low right now, that option it's not a great option. And so people are looking for a lot of, alternatives to these sort of traditional avenues for getting work authorization. One more thing on the L1 I want to talk about is a new office L. And this comes up a lot for people who have operations outside of the United States. So let's say you've set up a company in France and you want to establish a branch in the United States. A new office L is a really good option because the reason you qualify is by virtue of having that office in France and the office in the United States, you have that international connection of those two offices. And what you need to demonstrate to qualify is that, again, whoever's coming over, if it's yourself and you own the company, great, probably an L1A. You may decide you want to send one of your employees to open the US office, in which case they may qualify for an L1A or an L1B. But the main issue is when you first apply for a new office L, it's pretty likely that you'll get an approval to start with, but the approval is only valid for 1 year. And then the hard part is at the end of that first year, demonstrating that the company has met its business objectives, that the US operation is going to be viable. And so that's where you file for an extension after year 1, and it can be, that's like I said, that extension is the hard part. What we need to really show, one of the things the government always likes to see is hiring. So if you've hired new people, new US workers, then that's a really good sign that the company is doing well, that it's viable. If you have solid revenues coming in for the US operation, that's another good thing. One of the things I always recommend is having a business plan when we submit these applications, and then showing, according to the business plan, how did the company actually do? Did it achieve its goals? Did it move the needle on the business operations it was trying to achieve? The next sort of common work visa I want to talk about is an O1. So an O1 it's a pretty limited category in terms of who can qualify for an O1. And these are people who are considered to have extraordinary ability or achievement in their field of either science, education, business, or athletics. Now, typically within the science or the technology areas, we're talking about individuals that have a doctorate degree or a PhD. And the reason for that, I'll explain on the is on the next slide. For those who are in business or athletics, the degree is typically not as important. It's more about actual achievement within the field. And so what we're really trying to show here with an L1 is that the individual has national or international acclaim for the work that they've done, and that they're coming in the United States to continue doing that work. So what there are is there are 8 criteria, and I'll show you on the next slide what those criteria are. And we need to demonstrate that you meet at least 3. If you can meet more, that's great. But that you meet at least 3 of the 8 criteria. And then if you do, then you can qualify for an O1. And the nice thing about an O1 is that it is fairly flexible, sort of like the H-1B. It is considered sort of a quasi dual intent visa. It's not a clear-cut dual intent like an H-1B or an L1, but for all intents and purposes, you qualify for an O1 can actually move straight to a green card process fairly simply as well. So for that reason, we highly recommend people who can qualify for an O1. It's a great option. It does require employer sponsorship, so there's no option for self-sponsorship of an O1. It does require your employer to buy into the process, but it is a really nice option. So the duration, I'm kind of going out of order here. The duration is an initial period of 3 years and then 1-year increments. So even though there's not really a specific time limit, those 1-year extensions do get cumbersome. And so typically within the first 3 years, somebody who has an O1 and intends to remain in the United States on a long-term basis will begin the green card process. Okay, so then on the left here, you can see what the 8 criteria are. Original contributions, I put up there patents. Patents is a great way to satisfy that category, because obviously if you have a patent, you've done something new that nobody else has done before. Or you've added something novel to an existing process. So that would be original. Publications and citations. So a question that often comes up is, because if you look at number 3, we have articles written about you or your work. And a lot of times people think, well, I have 400 citations in Google Scholar. Unfortunately, USCIS does not consider citations as satisfying the third criterion there, the articles written about you. They really classify that as part of your publications record. So citations aren't enough. But if you do have, let's say, 10, 20 publications and you've got, a couple hundred citations, that's really good evidence that you've met the second criterion there. The third one, articles written about you or your work. This is where the article is mostly about the work that you've done rather than just sort of citing your work. A newspaper has written and said, hey, check out so-and-so's work. It's really great. This is what they're working on. That's the kind of thing that would satisfy the third criterion there. Major awards, these are things where it's not like company awards, where your company may give out an award for, the top engineer of the year or something like that. These are like grants, major awards that can be given through universities or other major organizations where a lot of individuals may qualify, but you were selected or you're among a few finalists. Those are what it means by major awards. If you've ever won a Nobel Peace Prize, then you're going to be able to satisfy that fourth one. Now, memberships. So one of the questions that comes up is if you have an engineer and they're an IEEE, for example, does that qualify? Typically not. What they're looking for is organizations that are memberships that are by invitation only. Where it's not like just because you're an engineer, you qualify to be in the group. Now, if you are an IEEE and you're a member of the board or something like that, then that could qualify because that's more of a restricted type of membership. You're at sort of a higher level within the organization. Previously employed by organizations with strong reputations. So if you worked for like a publicly traded company, that would be considered an organization with a strong reputation. Anything in sort of like the medical field where they've had, where they treat patients or where they've had medical research, things like that. Those are the types of organizations that would qualify as having strong reputations. Commanding a high salary. So what we would do here is we would look at the field that you're in and the geography that you're in and see what the anticipated, so the government has a whole database of what they anticipate salaries will be for each field, for each geography. So we would look at that and see if you're currently being paid more than 25% above what the anticipated salary range is for that field, then that would be considered commanding a high salary, and you would meet that criterion. And then the last one is judge or reviewer of the work of others. And the one here that kind of trips people up is if they've done peer reviews for articles and things like that. If you've done a lot of them, that can be helpful. If you've done just a few, typically that's not enough. What they're really looking for here is that you were a conference chair and you were key in selecting the conference posters or the articles or the presentations that we're giving as part of the conference. Or if you were an editor on a journal and you were instrumental in selecting which articles will be published, those are the kinds of things that they're talking about there. Okay, so that's 01. The next one I want to talk about, and I just want to reiterate for people who have joined later, these slides will be made available after the presentation, as well as recording of this presentation. So don't feel like you need to furiously be taking notes on all these. We'll provide this to you. So the J1 visa is one that is often overlooked, but in this era where H1Bs are so limited and hard to get, a J1 can be a really great option. It's an exchange visitor status for people from other countries. It's called a cultural exchange. The idea is there's a whole bunch of different categories within the J1 program. And the idea is that, we have this sort of exchange with other countries where people come in, they get, some training here or they get to work here, and then they take those skills back to their home country afterwards. And so that's why it's called a cultural exchange type of visa. Within the context of what we do, where with professionals and entrepreneurs and startups and things like that, the most common category we see within J1 are for interns and trainees. An intern is someone who is studying at a foreign university or has graduated within the last 12 months. So if you're currently enrolled in a university outside the United States, or you graduated within the last year, an intern might work for you. A trainee is those who actually have a degree, as well as 5 years of experience, at least 5 years of experience. So those are kind of the two main categories there. Now, I alluded to this earlier. The main drawback to a J1 is the potential for having to return to the person's home country for at least 2 years before they can pursue sort of long-term immigration benefits in the United States. A lot of times that does not apply. It comes down to the country that you're coming from, and what their required skills list is. So if you're from a country where they really need support with their financial industry and infrastructure within finance, then if you come here, to do work as a J1 for a year or year and a half within the financial industry, your country may really want you to come back and apply those skills and training that you've learned in your home country. Another way is if there is funding from either an institution from your country or an institution in the United States. The funding can be another reason that 2-year home residency requirement attaches. Now, if it does, that's not the end of the world. There is a waiver process. There's a way to get that 2-year home residency requirement waived, meaning that you don't have to return to your home country for 2 years before you can pursue long-term immigration benefits. But that's just something to be aware of with a J1 that can happen. So my advice is, if you're looking at a J1, we should really do that assessment ahead of time before you apply for the J1 to know whether you're going to be able to proceed from a J1 to some other status afterwards, or whether we're going to have to go through the waiver process for you. E2 is an investor type of visa. It's considered a work visa. And really, this is where you are making an investment, a personal investment, to start a new company. These are some definitions here on this page. And I should say, this link here in these slides that you can see right here, if you go to this link, it will tell you whether your country qualifies, your country of citizenship qualifies as a treaty country. So when you open that link up, you'll see a list of countries, and then by that you'll see E1 and E2. Your country it may just list your country and then E1, not E2. That means that you would not qualify for E2, or it may just list E2, or if it doesn't list your country at all, that means that you would not qualify for an E1 or an E2. So if you're interested in this, you should look at that website first and be sure that your country qualifies. So the idea here, these are some definitions, and on the next page, I'm going to explain what these means. Basically, you're making an investment that is not substantial, it's not marginal, it must be real and operational. You must have a controlling interest in the company, and that meant to. Okay, let's go back to this here. Okay, so an investment, what that means is that you're putting money at risk. So they're not talking about having money sitting in a bank account where you say, I intend to invest this at some point. It's money that you're actually putting at risk, meaning you've already spent it, you're already investing it. You got it in an escrow account or something like that, where it's going to go toward the operations of this business. The question that comes up all the time on this is, how much do I have to invest to qualify? And this is one of those areas where, unfortunately, the government doesn't give us a bright line rule. And I should say, for better or worse, because, in some ways it's nice not to have the bright line rule, because then it comes down to us being able to make that argument that this amount of money qualifies as a substantial investment for this type of business. Obviously, there's different types of businesses out there. Some require a lot of startup capital, some require less. So being able to make that legal argument is nice. Although in some ways it's nice that they just said, okay, it's got to be more than $25,000 or something like that. Then you would know. But I would say if you're investing more than $40,000, chances are you're gonna be able to meet the requirements of an E2, a qualifying E2 investment. So substantial, like I said, the money needs to be earmarked for things like equipment, inventory, website, office supplies, a lease or rent, things that you would anticipate a real company that is really, going to go for it and try to make it within its market space that they would be spending money on. What they really don't want to see is that people are setting up sort of shell companies that really aren't going to be operational just to be able to get themselves an E2 visa. In terms of whether the investment is marginal, again, one of the things the government loves to see with these things is that you are either hiring US workers or that you have a plan to hire US workers. And where this can be really important, this can be one of those areas that's really important to have a business plan. Being able to have that business plan and show that you're intending to hire, let's say, 10 people over the first year or something like that, that's something that will be significant in this type of application. Real and operational. So this is one of the easiest ways to do this is to buy an existing company. So if you put your money in to buy a company that's already operational, then obviously that company and that investment is real and operational because it already has revenues, customers, things like that. I would say if you are going to go this route and buy a company, you should make sure that it's a company that's profitable, that it has at least 3 to 4 employees. If it's a company that's losing money and doesn't really have employees, there's a good chance the petition could be denied as not being a real and operational company. In the non-immigrant intent. So we've talked a lot about visas where there is the dual intent, where you come in and you're going to work for a while, then you're intending to also apply for a green card at some point. Well, an E2 is actually one of those visas where you can't do that. If you are in an E2 and you file an immigrant petition, that immigrant petition will cancel out the E2 because there's a conflict of intent there. And so it's possible to move from E2 into a green card process, but it is riskier and it needs to be really well planned out. So I'm not saying that that's an impossibility, but it's because of that conflict of intent. It's something that needs to be navigated very carefully. Okay, the International Entrepreneur Rule. Now, this is not technically a specific work visa. What this is it's a rule that was created under the Obama administration with the intention of bringing in more investment dollars into the United States from other countries. So what it's considered is it's considered a temporary parole. So again, talking about that that non-immigrant intent versus immigrant intent, moving from being in this temporary parole status to a green card would be very difficult. Again, it's not something that's impossible, but it's just, I want you to be aware that this is not your standard flow from coming to the United States, working in a work visa, and then moving to a green card. It would require a little bit more strategy. But it's a nice option that's available if you do qualify to be able to come to the United States for a period of time to fulfill your business objectives. So one of the things, these are the requirements: that you're going to provide a significant public benefit within the United States, that there's potential for growth and job creation. Again, you're going to see that job creation come up all the time. If you can show in your business plan that you're going to be hiring and establishing new jobs, then that's something that goes a long way with the government. I don't know if I mentioned this, but with the E2, you have to own at least 50% of the company, but you don't necessarily have to be actively involved in the business. You could really just be an investor. But with the International Entrepreneur Rule, even though you only need to own 10% or more of the company, you do have to have a central role within the company. So the idea is you're coming here to be, one of the executives of the business. You're going to be involved on a day-to-day basis. It's going to be like your full-time job. And that's why you're here. You're not just a passive investor. It has to be a new company. So a US company started within the past 5 years. So it can be a brand new startup that you're doing, or it can be, a company that's say like 2 years old and you're coming in to become a new owner and to help participate. That can qualify as well. Now, the difference here again with the E2 is the E2 requires your own money to be invested. Whereas for the International Entrepreneur Rule, they're actually looking for other investment, not your own money. And so they call this a qualified investor. So if a company has a venture capital firm, let's say, that has put money into it, obviously they're going to be able to demonstrate a track record, or hopefully be able to demonstrate a track record of success, other companies that they've invested in that have done well. If the investment dollars are coming from an individual or like, one or a group of people, then proving qualified investor is more difficult, because if it's like their first investment, that's not going to work. If they've invested in other similar companies, over a number of years and they've had some success, that can qualify, but it's more difficult. Again, like if it's a VC firm, very easy to prove that. The amount here, they actually do give us a bright line rule on how much needs to be invested. And the tricky thing is, right now it's about $270,000, but it is subject to annual inflation. And so every year that number is going to change and it's going to go up in small increments. If it's government funding, the threshold is lower. Right now it's about 110,000. Okay, so with that, we're going to flip now into a discussion of the immigrant visa process, often called the green card process. This is what a lot of people are really interested in. So let's get to this. And the other thing that we're going to cover within this green card section is some self-petition options. So as we talked through those work visa options, there weren't a lot of self-petition options. The E2 is one, and that International Entrepreneur Rule is another one. Most of the other ones require an employer to sponsor you. So H-1B, L-1, O-1, J-1, those all require sponsorship from another organization. Okay, so the green card process is typically a 3-step process. And the first step is often what they call perm labor certification. Perm is for permanent. It's not for people who are getting curly hair. So what perm is it basically, most of the immigration benefits that we file go through the U.S. Citizenship and Immigration Services. They're really set up to handle these cases. They collect a government filing fee to pay their workers, their officers, to be able to handle those cases. Now, the perm process actually goes through the Department of Labor. And the difference here is they don't collect a fee for filing these cases. Their role is simply to protect U.S. workers. And so this requirement of a perm labor certification, what's happening here is your company is having to go to the Department of Labor and say, okay, we have this person, they're from another country, we think they're a great worker, but they're not going to displace any U.S. workers. We want you to sort of approve them for the green card process, which is more of a permanent process within the United States. And I just want to sort of give you that framework as we go through this, because then I think it'll make a little bit more sense on what the requirements of the perm labor certification are. A lot of times within the immigration space, you'll hear EB1, EB2, EB3. What that means is those are the different preference categories. And I'm going to show you sort of a snippet of what I'm talking about here in the slide after this. It's called the Visa Bulletin. And every month it comes out and it gives dates on when people are eligible to file for their green card. And so typically being in a higher preference category, so EB stands for employment-based, because there's also family-based. So if you're EB1, that's employment-based first preference category. EB2 is employment-based second. EB3 is employment-based third. To qualify for EB. So if you're going through the perm process, typically you're going to be under the second preference category or the third preference category. The first preference category actually skips the perm labor certification. So I'll explain that a little bit more as we go on here, but just to sort of make sure you have a framework there. One of the other things that's required with the perm labor certification, in addition to the company demonstrating that there were no qualified U.S. workers that were displaced as part of this process, is that there's what they call a prevailing wage, or like a minimum wage that needs to be paid. So as I talked about earlier, the government has a database of different fields and geographies. So within each geography, there's all these different fields, and they say, okay, somebody who's an electronics engineer in the Phoenix, Arizona area is going to need to be paid at least $92,500 or whatever it is. So then the company has to commit to paying at least that salary to be able to proceed with the perm labor certification. So I'm going to go on and explain what an I-140 is. So the second step is once the perm is approved, then you have the I-140. That's basically the first immigrant petition that's actually filed with U.S. Citizenship and Immigration Services, or USCIS. So it's like we've passed the Department of Labor requirement. Now we've gone back to USCIS and filed the first immigrant petition. Then the I-485 is the actual green card application. And that's where a lot of times the question comes in, I want to add my spouse or my children to the process. That I-485, the green card application, is where you add family members to the process. So this is the visa bulletin right here. This is just a snippet of the visa bulletin. And so the way to read this is we've got the first preference category, second preference category, third preference category along the left column there. Then as you go across the top, that first row, if you see a country listed, what that means is that country has oversubscription in there from that country. So there are 140,000 new immigrant petitions available each fiscal year. And then each country is limited to no more than 7% of those 140,000. So if you're from a country where more than 7% of those applications are coming from that country, then a line is going to start to form. And so these are the countries where we tend to see more people coming into the United States and applying for a green card. If your country is not listed in that top row, that means that you fall under this all chargeability areas, and that's your category. So let's say, for example, you're in the second preference category and you're from India. So if we look at that, then we've got a date here of January 1st, 2011. So what that means is that's the effective date for your category. Your second preference category, India, January 1st, 2011 is the current date. And what that means is that you need to have a priority date before that January 1st, 2011. So the question is, what is a priority date? The priority date is the first application that is filed in your green card process. So if you're going through the perm process, it's the date your perm labor certification is filed. If you're one of the people that's fortunate enough to skip perm and be in the first preference category, then it's the date that your I-140 is actually filed, because that's the first step toward your green card process. So that's your priority date. I like to tell people it's like you walk into a bakery, and there's a bunch of people standing around, and so you get to go up to the front and take your number. That marks your place in line. That's kind of what your priority date is. The date that your perm or your I-140 is filed marks your place in line to be able to apply for a green card in the future. The reason the second preference category for India is so long is because there's so many people applying who are from India who are applying for that category. Interestingly, and I said this earlier on, typically the higher preference category you're in, the shorter the wait you're going to have. But unfortunately, we've seen some categories where it's actually gotten flipped on its head a little bit. So if you look at, for example, the all chargeability areas column here, so just all other countries, where you see a C, that means current. That means there's no wait at all. You have a current priority date. But if you're in the second preference category, then again, let's say you're from France, then you have a wait in the second preference category. Whereas if you're in the third preference category, which typically is easier to get into, you have no wait. And so let me just explain quickly the difference between the second preference category and the third preference category, and then we're going to talk more about the first later. The second preference category is for people who have an advanced degree, so master's degree or higher. It does not need to be from a US university. It can be a foreign degree as well. So you have an advanced degree, or you have a bachelor's degree followed by 5 years of experience. So those are the people that qualify for the second preference category. The third preference category is people who have a bachelor's degree, but less than 5 years of experience, or in some cases don't even have a bachelor's degree. They might have an equivalency of a bachelor's degree based on work experience. Then they qualify for the third preference category. So historically, when I started my career 16 years ago, the third preference category was always the longest wait because most people qualified for third. Well, I think we've started to see a shift a little bit where we have more people applying that have advanced degrees or have those 5 years of experience. So because there's more demand in that second preference category, we're starting to see a longer wait there. And so one of the questions that comes up is, well, if I qualify for the second preference category, shouldn't I just file under the third preference category instead so I have a better date? The answer is yes, maybe. But my advice is always to file under the second preference category, because then you can file what they call a downgrade from the second preference category to the third, where you're essentially saying, okay, I qualify for the second, but I actually want you to process my case under the third because it's a better priority date for me. So my advice is always go for the higher, because you can't do the reverse. If you're in the third preference category and you want to file in the second preference category, you can't do that. You can only downgrade. You can't upgrade which category you file under. Okay, so this is the first self-petition green card process that I'm going to talk about here. This is where you don't need an employer to sponsor your green card application. You can file this yourself. It's called the National Interest Waiver, and it falls under the second preference category. So sometimes I have people, I'm going to go back up one level here. Sometimes I have people from India who say, well, shouldn't I file National Interest Waiver? And my answer is, I don't think so, because if you look at the second preference category for India, it's not really that good. I mean, we're looking at potentially a 12-year wait there. Now, I will say this visa bulletin comes out every month and the dates change. So there is some fluctuation there and the dates can jump around a little bit, but it gives you sort of a sense that if you're the second preference category India, that's a long wait. So I would say it's not really worth the extra money and time it's going to take to get into National Interest Waiver if you're in India. Now, if you're in another country, let's say you're in, you're from, let's say you're from Sri Lanka. Yeah, the second preference category could be very good for you, because the date here of July 1st, 2022, again, when that first I-140 is filed, which is the National Interest Waiver, that's an I-140. When that's filed, that marks your priority date. And then by the time that I-140 is approved and the I-485 is approved, your priority date, or by the time the I-140 is approved, your priority date is probably going to be very close to being ready, if not current. So National Interest Waiver is good for some people. It's not good for everybody. So in order to qualify for a National Interest Waiver, what we're showing here is that these four things. You have to prove these four things: that there's substantial merit, that it's in the national interest of the United States, that you're well positioned to be able to carry out that endeavor, and that on balance, it's beneficial to waive the labor certification requirement. So essentially what we're saying here is what this person is coming into the United States to do is so important that we don't really even want to check to see whether US workers are being displaced by going through the Department of Labor and that whole process. It doesn't matter, because what they're doing is so important to the country anyway. So again, substantial merit, this comes back to jobs. Are you going to be creating jobs? Do you have a business plan that shows that? And are you able to demonstrate that you have a plan to be able to add jobs? A lot of fields that we see qualify for National Interest Waiver within the medical field, anything to do with homeland security. That can be within banking technology, for example, or keeping the country safe in one way or another. A lot of times, again, that's through technology. It can be renewable energy like solar. education, the financial system. Those are the areas where we often see successful applications demonstrating that this is in the national interest of the United States. Somebody who's coming here to cure cancer, for example, or help map the human genome, those are things that we can demonstrate, hey, that's in the national interest. And really, right now with the banking system and sort of the struggles they're having, those types of applications are very successful as well, saying that this person's coming in to really help with our financial system. Are you well positioned to be able to carry out the endeavor? So one of the questions that comes up is, are you in the United States now? And if you are, great. That having that physical presence is important. If you're not, then how are you going to be able to get here and start doing the work? How is it going to be supported? Are there contracts already in place? Are there patents? Is there intellectual property there? Are there investors that are investing money? How are you going to be able to carry out the endeavor? So that's sort of the being well positioned piece. And then the fourth one, with people that are self-employed, a lot of times this comes up with people that are self-employed, especially if they're filing self-sponsoring, saying on balance, it makes sense to waive the labor certification process. Well, people that are self-employed can't sponsor their own perm labor certification. So a lot of times we're able to meet that argument by saying this person can't even file a perm. So if you're going to make them do that, then we're not going to be able to have them here. So on balance, it makes sense to waive that labor certification process. The next self-sponsor visa I want to talk about here is within the green card arena is the extraordinary ability. Now, this one is beneficial to everyone. I'm going to go back up to that visa bulletin snippet here. So the first preference category here, this first row, you see it's current for all countries except for China and India. But even India, that has such a long wait in those other categories, it's really only a year or so that we're talking about. So the first preference category is sort of the golden ticket, let's say. And so a lot of times people look at this and they say, well, I don't think I qualify for this now, but I'm going to start, making efforts to do some more of these things, so that in a year or maybe 2 years, I can actually file under the first preference category, because obviously that's going to be much longer, again, if I'm from India, than waiting for, 12 years under the second preference or third preference categories. So the EB1A, this mirrors the O1 that I talked about earlier. The requirements are essentially the same. So that's why, somebody who has an O1, typically they move pretty quickly through the green card process, because then they can file, essentially the same application under the green card process to show that they demonstrate extraordinary ability, which they've already done with the O1. And they can skip perm, and it's, there's not a lot of weight in terms of the visa bulletin and retrogression. I will just quickly cover these in case there are people who joined later after the O1 discussion. But on the right here these are the 8 categories: original contributions, publications and citations, articles written by others about your work, major awards that you've won in the industry, grants you've received, things like that, memberships in organizations that require achievement or that are invitation only types of organizations. Being employed with organizations with strong reputations. Again, if you've been employed with a publicly traded company, that's an easy one to demonstrate. That's not to say that only publicly traded companies qualify, but I'm just saying that's an obvious one. But companies that have been operational for years and have a lot of employees and have strong revenues and a strong product, those types of companies can qualify as well. Commanded a high salary. So again, looking at your geography in your field, if you're making more than 25% above what the anticipated salary would be, and then if you've done judging or review work of others in your field. The EB1 case it's pretty quick. It typically takes 1 to 2 months to gather all of the documents. So that's the hard part. One of the things that we have you do is we have you collect letters from other people in your field to be able to attest to the work that you've done. So that part of gathering letters can take a while. And again, as I said earlier, when we were talking about O1, for people that are in the sciences, technology, or education, typically they've earned a PhD or a doctorate degree. That's not a requirement, but as you look at these criteria here, obviously having a PhD lends itself to some of these things, like publications, winning awards, doing judge review work, things like that. So it's not required, but typically that's what we see. Within business, usually what we're talking about is somebody who has a track record. So this is experience where, maybe you worked at a major organization, you kind of worked your way up the chain there, and let's say you started your own company and then that company was successful. That's sort of like a track record that would be successful for business that might qualify for EB1. All right, so these last 3 slides here, as we're kind of coming close to the end, we've got about 5 more minutes. And like I said earlier, I'm going to finish this presentation and then I will get into the chat and answer everybody's questions. That part usually takes another 15 minutes to a half hour. And also these slides will be provided to you. So you'll have these for your own reference. So how long does each of these things take? I've got it listed out here. I mentioned earlier the premium processing. So a case that is eligible for premium processing on this slide, the PEP will be in green. If it's not eligible, it'll be in red. But what that means is the premium processing fee is an additional government fee. And right now it's $2,500. So it's a lot. But in some cases, you may decide that it's worth getting a quicker approval rather than having to wait the full processing time. And premium processing requires the government to respond or to make a decision within 15 days rather than whatever the listed processing time is. But keep in mind that that decision may be a request for additional evidence. So if you file, let's say with the H-1B, for example, you say, I don't want to wait 12 months. I've got to travel back to my home country. I need to get an approval before I go so that I can apply for a new visa. You may say, well, I'm going to pay the $2,500 so that I can get an approval within, like a month, and have that ready so that I can make my trip to, back to my home country. That may be worth it in that case. But if you're saying, well, I'm going to be here anyway, I'm not going anywhere, I don't want to pay that extra money, you don't need to. A lot of times, if you work with a company, and if you can prove that there's a business need to get the approval faster, your company may actually pay the cost for you. So again, where you're doing an international trip, let's say it's a business trip, they need to send you somewhere, and you say, well, I need to have the approval before I go so I can apply for a new visa stamp before I come back. They may pay that premium processing fee for you. The ones that you'll see here that do not qualify for premium processing are the J1 International Entrepreneur Parole. And then within the green card process, the Perm Labor Certification is not eligible because, again, that's filed with the Department of Labor. The I-140 is. So if you file a national interest waiver case, then you could file that with premium processing. And then the I-485 is not. Again, that's the actual green card application. And unfortunately, right now it's taking 1.5 to 2 years. So it would be so nice to be able to premium process those, but they're just not eligible for premium processing. But see, then if you look down at the bottom, the national interest waiver and the EB1A, those are self-sponsor options. They do allow for premium processing. And because they're 1.5 to 2 years, those are ones that I would recommend. I would think the $2,500 is worth it in those instances. This is just a reference, and I'm not going to go through each one of these. It's just to sort of give you a sense for what each of these costs. There's a range here, and sometimes it's a wide range because if the case is eligible for premium processing, that's an additional cost. Law firm fees tend to vary. For the most part, most major firms I know, the fees are going to be, not too different. You'll find some firms that charge a lot more or a lot less than sort of like the down the middle firms. So you can do research and find cheaper or more expensive firms. So that's why there's some range there. But most of the major firms will charge sort of roughly the same fee for these types of cases. And then the last issue is if there's dependent family members, obviously there's additional costs if you have a spouse and children you're sponsoring as well. Then this last slide is how long are they valid, and is it a dual intent status? again, this is a reference. You'll get these slides so you can have these in front of you. So I won't go through each one. But some of these, and one thing I should add with the H-1B again is the flexibility of extending beyond that 6-year limit. Unlike the L1, where you can't extend beyond the 7 or 5-year limit. L1 does not have a limit you can file, but again, it's those 1-year extensions. So initially 3 years and then 1-year extensions after that, which gets really cumbersome. If you've got an L1, you might as well go for the first preference categories, extraordinary ability for a green card. So a lot of people typically don't even get into those extensions. All right, so with that, let's move to questions. I'm going to go here into the chat and start going through these questions here. Okay, so the first question is said they increased the cap from 65,000. Yeah, that's right. So the regular, no, they didn't increase it, unfortunately. The regular cap is 65,000. Then there's an additional 20,000 set aside for those with advanced US degrees. So that's how I come to that 85,000 number. This is one of the areas we're really hoping that Congress will help us with. About 20 years ago, they did an experiment with the H-1Bs and they bumped the number from 85,000 and it kind of crept up, and it had a number of different levels. I think at one point it got up to 200,000, maybe 250,000. But back then there wasn't as much demand for H-1Bs, so those limits weren't reached. And so they brought it back down to the 85,000. Well, obviously we've exceeded the 85,000 for years now. The demand is so much higher. So really, we're just hoping that Congress will see that and raise that. The problem is if you follow US politics, I'm not going to weigh into politics too much here, but there's sort of two sides, and one side wants to attach different things and the other side sort of fights those things. And so a lot of times when it comes to immigration, we find that there are stalemates within Congress. So it's my hope is that they'll just have a bill that's simply for the H-1B just to raise that number, but that's what we're stuck with right now. So the question says, what about degrees from the UK? I'm not exactly sure what that's in reference to. When we're talking about the H-1B cap and that advanced degree cap, that has to be from a US institution to qualify under the advanced H-1B lottery cap. So a degree from the UK would not qualify. If this question is in reference to qualifying under the second preference category for a green card as an advanced degree, then yeah, the UK would qualify. Any country outside the United States qualifies. The only thing we have to do is we have to show that the country you're from, if they call it a master's degree, that in the United States, they would agree that it's also a master's degree. So we're sort of looking at the number of units you've taken, the number of classes. There are some degrees where the body of education evaluation within the United States will say this is not equivalent to a master's degree. This is more like a bachelor's degree, followed by like an associate's degree or something like that. So there are instances where a foreign master's degree is not considered equivalent to US master's degree, but for the most part, they are. The next question says, what qualifies an employer as an H-1B L1 sponsor? Can it be a newly formed company? That's right. So a new company can sponsor for an H1 or an L1. It does not need to register or certify in any way. It can be a brand new company that says, we're going to go ahead and sponsor this person for an H-1B. I have a lot of times where it's a brand new startup that does it. So as long as the company can show that it has the financial ability to pay the required salary. So with an H-1B, there's a required salary that has to be paid. And as long as it can prove that it's financially viable enough to pay that salary, that's kind of the main issue there. So yeah, it can be a newly formed company. Same with the L1. So with the L1, if it's a new company, we're probably looking at that new office L rather than sort of a regular L. If it's a company that's been operational in the United States for a long time, and there's also a related organization outside of the United States, then a regular L1 might be possible. Okay, there's an advertisement. Someone's working remotely. Okay, so I'm going to read this one out loud. It says, how about if someone is working remotely for a US-based company? For example, I'm a partner at a marketing agency out of North Carolina, working remotely home in South Asia. So in that instance, you would need to be able to show that you're working for the foreign entity. So if you're in South Asia and there's an entity there, even if you're working remotely, that's okay. You don't actually have to be going into the office, but you have to be affiliated with that organization, meaning that you're on their payroll, that you report to somebody within that company, that foreign company in South Asia, for at least a year, and then you could potentially qualify to transfer to the US office. Okay. Okay, this question says, if you set up a US-based company and need a visa to travel to the US to do business, what type of visa do you need? So this would depend on what type of visa you're coming over on. So for example, if we're doing the new Office L for you, then you would apply for an L1 visa. If you're coming, let's say, for example, you're not quite ready to come full-time into the United States, but you want to come here for a short period of time ahead of time to, meet with people, or to set up a lease for office space, or to meet with colleagues or something like that. You could come over on a business visa. So this is typically a B1 visa that you would apply for. If you're from certain countries where the visa requirement can be waived for business travel, called ESTA, you might be able to come over under ESTA without an actual business visa. So yeah, you're either looking at a B1 or ESTA there. From your experience, how many US hires are sufficient to extend the L1 new office extension? Is 2 employees enough? It can be, and this is one of the areas where it's sort of a blessing and a curse that we don't have specific rules, where the government says it's got to be 3 or it's got to be 4, or you have to invest 40,000 or whatever it is, because what we'd be looking at is the type of business that you have, sort of what the expectations are in the industry for that size of company, for that industry. So again, it comes down to a legal argument. So yes, 2 employees could be enough. Certainly as your attorney, I would say, yeah, that it is enough, and we're going to make a strong argument that it is. So yeah, again, there's not a bright line rule there. We would just make the legal argument that it is. Regarding E2 visa, what does substantial mean? Can it be done via a parent company? So the E2 visa is an individual investor visa. So if a parent company is making the investment, then that's not going to qualify. So what you would do is you would have, if it's your endeavor, let's say, for example, so you're wanting to invest your own money to start this thing up, you would invest your money and you would get the initial E2 to qualify yourself. Then once you have the E2, it's sort of almost like a blanket approval for other employees to qualify for E2. So once you have your own E2, then you could send other employees. So under this sort of parent company scenario, what I would say is whoever owns that parent company or is an executive within that parent company, and wants to make that investment to qualify for the E2, they should do that, and then they can send other employees under that already approved E2. Next question, is an E2 an immigrant or non-immigrant visa? I think I missed it. Okay, so yeah, so E2 is a non-immigrant visa. It's a work permit, and it's a non-dual intent, which means if you're in an E2, it's not anticipated that you're going to apply for a green card. So if you do actually file an immigrant petition, like an I-140, then that will nullify the E2, meaning the E2 will no longer be valid. That doesn't mean that you can't move from an E2 to a green card. It's just, it takes more strategy and planning to be able to do it than like an H-1B, because an H-1B, you can have the H-1B valid while you're also doing the green card process and have them go in parallel. They don't cancel each other out. Unfortunately, with an E2, it would be canceled out by the immigrant petition. So again, there needs to be some strategy and planning with that. All right, can you apply for multiple visas at once, an E2, an H-1B, one, etc.? No. So you you would be in a specific status at a given time. So if you were in an H-1B and you wanted to apply for an E-2, you could do that. You would file a change of status, but you couldn't have both at the same time. So you couldn't be here with an E-2 and an H-1B at the same time. How much is the budget to cover all advice, immigration process? Average around, please. Yeah, so that slide that I sent that has sort of the range of costs will be good to look at. There's obviously a wide range depending on the type of visa, whether you're eventually going to apply for a green card, whether you have family members, whether you're going to do premium processing. There's a whole list of variables there, so it's kind of a wide range. But again, these slides will be available afterwards. We're going to email these to everybody, so then you'll have those and you can kind of refer to that. Is it necessary to spend a portion of the capital before applying for the E-2 visa? Not necessarily, but you can't just have it sitting in a bank. So that's kind of the distinction I want to make. They want to show that in some way it is at risk. So either showing that you spent it is obviously great evidence that you've put the money at risk because you've already spent it. If you haven't spent it, that doesn't mean you can't make it at risk. It just means that you have to sort of separate in some way that you've put this money out there. If the business succeeds, you're going to do great. If the business fails, you're going to lose your money. That's really what they want to see there. How about Nigeria? Nigeria is great. I've never been there, but I would love to. But yeah, people coming from Nigeria can definitely qualify for these immigration benefits. Could incorporating the company in the US lead to the cancellation of an I-130 application, given that a working visa could be required afterwards? Currently hold B1, B2. So incorporating a company in the US will not would not impact a person's immigration process. It would be, so that would be sort of a separate thing. You know, you would incorporate the company and then you would have your immigration process going on. The conflict I see here potentially is if you're in a B1 or B2 and you have an I-130 application filed, a B1, B2 is a pure non-immigrant intent. So that I-130 is a step toward the green card, and that would nullify the B1 or B2. So if you had an I-130 filed and you were later able to get a B1, congratulations, somehow the government missed it. But there is some risk in doing that because it does create that conflict. And so if at some point they see that you were an intending immigrant, but you came in under a pure non-immigrant intent status, that could eventually create a conflict at some point. What immigrant visa is valid for 5 years and is eligible for green card that is filed with a DS form 160? This seems like a trivia question. I'm not sure I have the answer for that. The thing I will say about when you apply for a visa stamp, that's an entry document to come into the United States. And depending on reciprocity with your country in the United States, that visa stamp may be valid for a longer period of time or less. So that's where you can see some variation. So it may be that the person from this country got a visa stamp that was valid for 5 years. There's, in terms of an immigrant visa valid for 5 years, I can't really make sense of that because as you're an intending immigrant, there's not really a time limit. And once you actually get your green card, the green cards used to have no expiration date. Then they started putting a 10-year limit on the green card. And then now they're kind of going back to no limit because it was confusing for people to get that 10-year limit on their green card because then they thought, well, does that mean that I'm not in a lawful permanent resident of the United States anymore? The answer was no, you still are. It's just that the card expires. They want you to come in and do new fingerprints and a photo. So hopefully I answered that question. If I didn't, feel free to reach out to me and I can talk to you more about that. Yeah, so the recording of the slides will be emailed to everybody, hopefully later today, or if not tomorrow, you guys will have that from us. We currently have E2 status. Can you apply for EB2 national interest waiver? Again, this move from E2 to a green card is tricky. So yes, it's possible, but it would take some strategy and planning to be sure that you don't experience a gap in work authorization or a conflict of intent. So yes, that's possible, but it would take some careful planning. What about the E1 visa for a company that trades with a foreign branch of US companies? Yes, that's an option. And I didn't raise it here because often, with this group, we don't have people that are doing trade between a qualifying foreign country and the United States. But it's similar to the E2 visa. There's a list and I'll send you these slides again, and it has a link in there where you can look at that link and see if your country is listed. And if your country is listed and it says E1, then you can qualify as a trader. And so if you're doing trade between the United States and your home country on a regular basis, you can qualify for an E1 visa to come to the United States. It operates very similarly to an E2 in terms of its time limit and the ability to move to the green card. After an H-1B is picked in the lottery, and while filing a petition, are we required to be already working with the company like in March, October, or can our start date be mentioned as October 1st? Yeah, so if you're picked in the lottery, and chances are your case is either being filed now or has recently been filed. So when it gets approved, it will have a start date of October 1st on it. So you actually can't start in your H-1B status until October 1st. There's no way to start early, unfortunately. The other thing to be aware of is how the petition is filed. Some H-1Bs are filed as a change of status. So let's say you're like an F1 student, and that petition was filed as a change of status. That means on October 1st, your status automatically changes from F1 to H-1B. If it was filed for consular approval, what that means is that the H-1B will not start automatically on October 1st. You will still remain in F1 status until you travel outside the United States, get an H-1B visa stamp, and then re-enter the country in an H-1B. So that's something to be aware of, is to make sure that your case was filed as verify whether it was filed as a change of status, where you automatically change, or as a consular approval. Okay, could you please share the H-1B checklist link based on your experience in the field? This would be very helpful for folks when we work on our filing. Yeah, in terms of like what documents and information is needed. I can put together something. I'll send that out with the slides. I'm making a note to myself here to remember to do that. Okay, I got an I-140 in 2012. My priority date was too far away, so I left the country. Does it make it easier to apply for another one? Not necessarily. So what we would need to determine is whether, and whoever has your immigration file will be able to look at this to see whether you can still benefit from that priority date. You may still be able to benefit from that priority date, in which case, that would make it easier because, as I mentioned earlier, the analogy of walking into a bakery, you may still hold that ticket for your place in line. If you don't, if it was abandoned, like if it was withdrawn, then you would really be starting from the beginning again. Okay, my wife got an offer from a company to relocate to the US. With a secondment contract from the Netherlands to the US. What kind of visa do I need in order to search for a job there once we have both relocated from France? Okay, so she's coming. So it would really depend on what visa your wife is getting. So it sounds to me like this may be, she's coming over under an L1 visa, in which case you as her spouse would qualify for an L2 visa. The nice thing about an L2 visa, not all spouse visas qualify for work authorization, but an L2, you can get work authorization as a spouse. So that's a nice thing. You wouldn't necessarily need your own sponsorship just by coming as her spouse, then you could potentially have your own work authorization. So yeah, so if she's coming on an L1, you're looking at L2. I would like to ask about the O visa. How about for the spouse? Will it be possible for the spouse to come, and with what visa can the spouse also work? Yeah, so a spouse, so if you're coming on an O1, your spouse would come over under an O3. And unfortunately, unlike with the L2, O3 spouses cannot work just based on their O3. They would need to get their own sponsorship. So your spouse could come here, live in the United States, but in order to get work, would need to find an employer that would sponsor his or her own work authorization, separate from the O3. What if you invested in the country, rent an apartment, put money in the bank? What immigrant visa would be best? So if you invested in the country, bank. I'm not really sure from just that list. Renting an apartment doesn't necessarily help. Putting in money in a bank doesn't necessarily help. The investment may be the key here, depending on what you're investing in and how much you're investing. So I would need to know more to be able to fully answer that question. Let's see. For a company from a treaty country that is both trading with the US, holding a US subsidiary, and employs 5 people abroad, what is the optimal visa type for the manager wanting to relocate to the US? So this sounds like going back to that E1, the trader visa, E1 trader visa might be the best option. And again, the nice thing, kind of like with the E2, once you get that E1, then you can have, it's sort of more of like a broad or a blanket type approval. You can have more people come in under that E1. So I would say probably E1 would be best there. Next, it says, if I'm an angel investor and I invest in several startups, I usually have the option to purchase 1.5% to 1% interest of these ventures. Would that qualify me for any type of visa? And if so, what would the minimum total investment amount? So unfortunately, the E2 would not work here because you need to own at least 50% of the company. International Entrepreneur Rule would not work either because you need to own at least 10% of the company. So it sounds like there may not be a good option just based on those investments in and of themselves. Really, what you could do is you could come in as a business visitor. So that's where we're going back to the B1 or the ESTA to be able to check on your investments, to do meetings and things like that, but it wouldn't be a long-term option. Okay, do we need to have our university transcripts for a bachelor's degree, non-US university, and master's degree, US university? STEM OPT was based on master's while filing for the H-1B. Yeah, so if you're filing for an H-1B, that you will need your academic records from your home country if you got a bachelor's degree or any degree from there, and then also from your US university as well. Okay, we are an IT company in India planning to register a company in the US. Do we need a physical office and tax ID before we apply for an L1? And how old the company should be in the US as well as out of the US? So the company in India should be operational for at least a year. Longer is better, but at least a year. And then in terms of the physical presence in the United States, yes, I won't say that it's a requirement to have a physical office address and tax ID before applying for the L1, but it makes the case a lot stronger to do that. So that would be my recommendation, to be able to get at least a lease in place and have a tax ID. Okay. So it says, are we required to submit any of the last tax return documents along with the H-1B? So you don't need to provide, for an H-1B, you don't need to provide personal tax return documents. The financials that will be required will be from your company, not from you individually. Let's see, what visa would be best for a sport instructor coming from South Africa? That's a good question. I mean, there could be a number of different options. One of the ones that we often look at is if you have had your own career, in whatever the sport is, and you've been on a national team or something like that, we could look at an O1 potentially in athletics. If not, we could look at a coach category for like an H-1B. If it's an institution that has foreign offices and US offices, we could look at an L1. So there's a number of options there. I would say reach out to me, with like a CV or a resume, and I can give you more specific options there. Does providing services to US companies via their foreign subsidiary qualify as trade, according to the definition of E1? Providing services to companies. Yeah, so it can be services or it can be products. So that's a possibility. Again, if you want to talk more specifics on these things, some of these questions are kind of hard to answer, in sort of a vacuum, but like I said, feel free to reach out to me and we can have more sort of in-depth conversations. It says, can I apply for E2 national interest waiver while waiting for H-1B filing decision? Yes, you can. And again, the nice thing about a national interest waiver is you can self-sponsor. It doesn't require your employer to do that. Depending on your circumstances, I would say that often it's nice to tell your employer what you're planning on doing so that it's not really a surprise to them. But I do understand in some circumstances, it doesn't make sense to notify your employer. But a lot of times companies are anticipating filing for your green card at some point in the future. And so if you say, well, I would like to do this, I think I qualify, my attorney thinks I qualify, the company may actually pay for it for you, pay for that process. So sometimes it's worth coordinating with your company on that. So you mentioned we need academic record for bachelor's or master's degree. Would our diploma degree certificate be sufficient, or do we need to request official transcript? I like to have the transcript if I can. If you don't have that, we can file with just the degree certificate. But it's possible we could get a request for evidence, especially if we're saying that, in an instance with like the advanced degree cap in the H-1B, where we're saying it's an equivalent to a US master's degree, we would need to be able to show those transcripts and demonstrate the classes that were taken and everything specific. So I like to have the transcript if I can. If not, we could file without it, but there may be a request for evidence. What are the common questions for USCIS not to approve L1 new office extension? So the common reasons are that the company is not financially viable, that no one has done that on the extension, you haven't demonstrated that there are revenues coming in already, or that they're going to come in based on agreements or contracts. There hasn't been any hiring. Again, you have that business plan that we would submit. And if you haven't met sort of the standards there with that business plan, then that's often where you'll get a denial. And I will say that those new office extensions can be pretty tough. So, we really want to make sure ahead of time before we jump into this, that there's a good chance on extension that we're going to be able to show solid revenues. Okay, can apply for national interest waiver while waiting for H-1B. I think I answered that one. If I haven't done that adequately, again, feel free to reach out to me. We are just about at our time limit here, so I just want to get a couple more questions in here. Oh, thanks for the nice compliment. See, due to the market volatility at the moment, if I go through perm plus I-140, to what point must stay with the company until I gain something transferable? How much time do I have to stick with that company? Yeah, that's one of the things about the traditional employer-sponsored green card process, is that it does sort of tie you to that company for a while. So with a perm and an I-140, once you get that I-140, and I kind of said this to a question earlier, once you get that I-140 approval, that sort of holds your priority date. It can hold your priority date. So then at that point, if you switch to a new company after the I-140 approval, the new company would have to do a new perm and a new I-140. So that part is not fun, but you would be able to keep that earlier priority date. So let's say, for example, you're from India, EB2, where you're thinking I may have to wait 12 years anyway. I might as well move to this new company. They're telling me they're going to file my perm and I-140, and I get my earlier priority date anyway. In that case, it might make sense. Where you can actually transfer your whole green card process is once you file that third step, that I-485, the actual green card application, and that's been pending for at least 180 days, then it's considered portable. So that's a very narrow set of people. But once you get to that 180 days, then you would go to your new employer, and as long as it's a similar position, and the new employer is willing to take on that obligation, you can actually port your green card process to that new employer. So again, once you start the green card process, you're pretty much tied to that current employer that's sponsoring you, unless you're willing to sort of break the process, go to a new company and start over. Let's see, is an unofficial transcript sufficient? It sometimes takes a non-university longer. Yeah. So again, this is kind of like, what can we get and what would I like? I would like the official transcript. If you can only get an unofficial, then we would start with that and then see if we get a request for additional evidence. And then if we do, we'd have to go try to get the official transcript. Okay, can you please share a few key points related to H-1B amendment when project details change? Okay, H-1B amendment. So this is a good question. If you're with a company and you have an H-1B and you change job location, that may require an amendment. Where your job responsibilities change, that may require an amendment as well. So job responsibilities, typically, if you're taking promotions, those don't count. Those don't count as something that require an amendment. So if you're like a software engineer, then you become software engineer 2, and then a senior software engineer, those are the kinds of things where you're fine, probably no amendment. But if you're a software engineer and you think, well, I did my bachelor's degree in finance, let me shift over to the financial department and do something different, that might be the kind of shift, or that would be the kind of job duty shift where we would need to file an H-1B amendment. The nice thing I will say about that is that you're not subject to the H-1B cap again. So once you've been selected in the cap, you can file extensions, you can file amendments without being subject to that lottery system again. You can file it. And the other thing is if you are going to make that kind of change, you should have the amendment filed before you make the change internally within the company. Okay, so for a scenario where you're applying for F1, applying for H-1B for the first time. Okay, so if you're applying for an H-1B for the first time, then it doesn't really matter what you're doing under F1. Having a job change, whatever you're doing under F1, and then it changes when you're becoming an H-1B, that doesn't matter. All right, let's see. This is the context for my question, the H-1B amendment. Well, I'm sorry, I'm not sure I totally understand, and we're out of time here. So I would encourage you, Sam, to go ahead and reach out to me, and let me take a little more time to address your question. Thanks, everybody. I appreciate it, and look for an email from us later. All right, bye-bye.